Hi, in this session we deal with the consulting contract. This is the agreement between client company and consulting firm, or customer and consultant. In the consulting contract, a certain agreement is made, primarily on what the services or products will be that will be delivered by the consultant, and what payments will be made by the client company. Now, this agreement is very important because it's project-based. Now, project-based agreements are very different to process-based agreements. A project-based agreement always has the time, cost, and quality factor there. In other words, it's going to cost us a lot of money if it's going to be in a short period of time, or if it's high quality and short period of, there's always these three elements there. Therefore, it's a contract which is tightly managed because it also expires after a certain time. If you finish with your consulting service, then it doesn't continue like an employment relationship, which is more process-based. So the best in this type of agreement is to put it into writing. I'm going to tell you what a contract is. We're going to look at the nature of contracts and the nature of agreements and what should be inside the consulting contract. Yes, a contract can be verbal, it can be by means of a letter, but we recommend that it's always a written contract, especially due to the nature of the disagreements that can arise. Let's have a look at the different consulting contracts, but let's start at a place where we investigate what is a contract. What's the definition of a contract? How do we define this? A contract is an agreement entered into by two or more people with the intent of creating a legal obligation. The crux here is on legal obligation. When two or more people agree on something, there's a contract. This does not have to be written. It could be verbal. It could just be agreement. For instance, if I go to a hawker who's selling an apple for $1, then there is an agreement and it's legal. In other words, there's obligation on both sides. The hawker has to give me an apple and I've got to give the hawker $1. That's the agreement. Now, the agreement has to be legal. I can't agree to kill somebody. It's not legal. Now, let's say a consultant agrees to do a specific work at a given time, at a given cost, and at a specific quality. If the client agrees to pay this for such service or to pay a specific agreed upon amount for such service, there is an agreement. This agreement doesn't have to be in writing. It could be an email, it could be a letter, it could just be verbal. The fact that both parties agree to apply to each other a very specific delivery, and the fact that both parties have done into, they are of age, they're not underage, because then it would be illegal, then it's a binding contract. The first requirement for a contract to be valid is consensus. This implies that both parties must agree. You cannot force somebody to sign a document and then claim that it's a contract. A contract there must be conscious consensus. So if you trick anybody into doing something, or if you make somebody to sign a document and they didn't know what they are signing, that contract will not be valid. In terms of minds, it means that people must be compos mentis. They must know what they're doing. They must be of age. It must be in material terms. In other words, you must be able to measure it, and both parties must be aware of what the delivery on each side is. Then only can there be a contract. So consensus is very important. Do not think that people can trick you into something, or ask you for a signature and then afterwards claim that this was a legal contract. No, there has to be consensus, and both parties have to be consenting in terms of mind and material terms. The second requirement is capacity of parties. What this means is that the parties who consent to the contract must have the capacity to do so. Now, in most countries around the world, the legal age for somebody to be able to make a contract is 18 years. If a person is younger than 18 years and sign a contract, that contract would be regarded as not valid in a court of law. The second way of having capacity is the mental ability. Many people have a mental illness or are mentally disabled, will never be able to undergo a valid contract because they do not have the mental ability. In other words, they will never be of age. A good example of this is many court cases where men would have sexual intercourse with a female at a very young age, a minor. Now, the first rule here is that the minor cannot consent to such act. In other words, there cannot be agreement. And most of the cases, such an act is called rape. So both parties must have the ability. You cannot conclude a contract with somebody that does not have the ability to do so. That person must be of age. That person must have mental capacity. In legal terms, we call it the person must be compos mentis, must be of a mind which in a state in which a contract can be concluded. Another example would be a person with the mental capacity, but such a person might be unconscious or not conscious, or under the influence of alcohol, or under the influence of drugs. Such a person may not conclude a contract, and if it's proven that you were under the influence of liquor or under the influence of seducing material like drugs, then such contract would not be valid. The third requirement is formalities. Now, the basic formality is that both parties must agree, must have consensus, and must have the capacity. Now, I put in brackets here that it usually is in writing and signed. This is not a formal requirement for contracts. You can have a contract if you just agree. A gentleman's agreement is a contract. The problem, however, is that it is very difficult to prove. Therefore, we suggest that when you enter into a consulting agreement, such contract is signed and is in writing. This just cuts out the ambiguity. This sorts out any disputes. In other words, at a later stage when somebody says there was no contract, you can produce a document and say, well, here the person signed, therefore there was a contract. So it is good to have a contract in writing, in legal terms, and signed. It's good to have witnesses there. Now remember, the witnesses do not sign that they know what's in the contract. They're just saying that they witnessing that you are signing whatever's there. So the witness doesn't really have much to do with the content. They're just telling that this person who signs is a person, is you. So in writing is recommended. A fourth requirement is legality. In other words, the contract must be legal. If there's a specific statute, law, or common law or bylaw that regulates a specific thing, then the contract which you conclude must be within these laws. A very good example would be if you bet somebody that a football team would win on Sunday, and in that place where you make such a bet, betting or gambling is illegal, well, then that contract will not be enforceable. In other words, if the person loses the bet, you will not be able to take that person to court and say that such a person must pay you, because betting is illegal because it's gambling in that specific place. If you are making such a bet in a place where gambling is legal, but you do not have a license to gamble, then it could still not be enforceable. So it has to be legal. You can't, as I said earlier, agree to kill somebody or hurt somebody, because these things are illegal under common law. Another good example would be where you want to make an adjustment to your house. You contract a builder, and you set a contract with a builder that you must build. That whole contract might be illegal because there's certain bylaws regulating how houses should be built. So there should probably be plans that must be approved first, etc., etc. So legality is a formal requirement. If you're a consultant and you going into a contract with a party, then it must be a legal contract. In other words, the laws within the country or area or province where you execute your consulting project, what you have agreed upon must be a legal agreement. The fifth requirement for a valid contract is possibility, especially at the time of execution. In other words, it must be possible to execute the contract. One of the things I put in brackets there is force majeure clause. The force majeure clause implies that force majeure stands for force of nature. In other words, if you contract me to build a wall at your house and there's a hailstorm at the day when I should build the wall, then it's simply not possible for me to do that. There was no ways in which I could execute that contract. And the reason I couldn't do it is because of forces of nature. I cannot control the weather, therefore I can't build your wall. You do not have a claim against me. You can't say that I failed to deliver on the contract because it was not possible for me to deliver. In the consulting world, a good example is a consultant that has to facilitate a workshop. On the way to the workshop, the consultant is in a car accident and has to go to hospital. There was no ways in which such consultant could facilitate that session, therefore the company would not have a claim. If the contract was made with a consulting firm and that consultant could have been replaced by another consultant, well, then they do have a claim, because all the firm had to do is just find out about the accident and then send somebody else. But if a court of law determines that it was not possible for you to render that service, I myself consult internationally. And I remember one time when there was a delay in flights. There was no aeroplane to get onto. Therefore, I was late at a specific engagement, and there was nothing the people could do, because it was impossible for me to be on time. Alright, so possibility, it must be possible at the time of execution to actually do this. And the impossibility must be outside your area of influence. In other words, that which makes it impossible for you to commit to do execute your task or deliver on the contract must be something which you had no control over. A sick child, for instance, well, that would not be an excuse. A hailstorm where you have to build a wall outside, well, that would be. The last formality for a valid contract is certainty. Agreement must have a definite and determinable content, and obligations must be clear for enforcement. The first certainty must be that there is consensus, that the parties who consented have capacity, that all the necessary formalities have been met, and that it's legal, and of course that it's possible to actually execute this contract. Therefore, the delivery in any contract must be in clear, quantifiable terms. It wouldn't be a certain contract if a client said that they would pay you. There's no certainty in how much they would pay you. Therefore, that's not valid. A contract must say, well, the client will pay you $9.99. That's clear. There's certainty in exactly how much you must get. On the obligation of the consultant, it must be clear on what exactly the consultant must deliver. In other words, the client won't just say, well, I'll pay you $9.99 if you facilitate a strategy. There should be clarity on specifically when should you facilitate this strategy. How should this strategy be facilitated? Where should this be done? How long is it going to take, etc., etc. So on both sides there must be certainty on what exactly is going to be delivered here. The first key element to the consulting contract should be the aim of the consulting project. In other words, quite at the beginning of this document, whether it's a letter of agreement or whether it's a standard contract, should be a clear statement on what this consultancy aims to achieve. I myself often consult in the field of strategy development. So I would begin, well, very early in the contract, after the definitions, I would state that on completion of this consulting contract, or this service aims to facilitate a strategic session for the department of so and so and so. Then we know, if we read the contract, this is about facilitating a strategic session. We can get more specific on the services that should be exactly rendered a bit later in the contract. Now that we've stated the aim of the project, we can get specific. What specifically do you have to deliver to the client? What is the client expecting from you? Yeah, you could broadly be specific on what you have to achieve. In other words, firstly you say we want to facilitate the strategy session, and then the specifics would be that we're going to consult or have interviews with all the relevant role players. After this we would construct a design plan for the session and give it for management to approve, and after approval we'll run the session for so long, and then we'll issue a report, something in that line. So you're specific. I must be honest, what I like is an attachment to any consulting contract, which is the project plan. The project plan is as specific as you can get to the services that had to be rendered, especially in terms of time, resources needed, and dependency flow. So a project plan is always good. Some clients require a project brief, in other words, a short executive summary of the project that should be attached to the contract. Next is defining delivery from the client. In other words, what are your expectations, the consultant's expectations? Just as the consultant has to specify what they have to deliver, or what we have to deliver, the client has to specify what they have to deliver. Mostly this is a type of payment or a payment arrangement, or It could also be that certain resources are done. Very often I facilitate sessions at the premises of the client. So this must be clear in the contract that they would be supplying the premises, they would be supplying the catering, they would make the logistical arrangements. So what precisely do they have to deliver in terms of this contract? Next is the names of the project team with their roles and responsibilities. It's important that it's contractually decided who the project team would be, what their qualifications are and experience is, so that if one of these people fall out of the team, there could be obligation on the consulting firm to provide people with the exact same type of experience and background. Now it's time to work with the duration of the contract, or rather, when would this contract start and when would it finish? So the project could be defined in terms of dates or expiry of specific number of consultancy days. Whatever the case may be, in rare occasions there's even the achievement of certain deliverables. Whatever the case may be, this must be clear. When would this contract start and when would it finish? The most qualifying characteristic of a project is that it starts and it stops. And the more clear we are about the exact quantification of this start and finishing point, the more manageable such a project becomes. Within any formal agreement, there needs to be a termination clause. It's very rare, but there are times that a contract is terminated before the actual finishing time. There should be, therefore, mechanism and notice required for such a cancellation. This could be to a variety of reasons. I've even seen reasons where the company simply goes bankrupt, and then the contract is automatically terminated. Or, for some legal reason, they're not happy with the work, or the consultant is not happy that there's been a delivery on the client's part. But there are very rare times that contracts get determined. For the time, the termination clause should exactly spell out how this is done and what the requirements and what the details are for terminating a contract. Let's look at the payment arrangements. These must be very precise. It's unlikely in a consulting project that you would be paid all the money afterwards or all the money before, except if it's a very small project such as facilitating a 2-day session. But usually consulting projects last for 6 months to even 5 years. Therefore, there are certain terms of payment and certain intervals of payment. Now, these could vary. Very often, these are the milestones of the project plan. So wherever there's a milestone, there's a payment. Some payments are measured in weight. In other words, if the milestone weighs 30% of the project, then the consultant gets 30% of the payment at the completion of that milestone. Many times consulting firms do not have the startup capital. Anybody who's been in this industry would know that the start of the project is the most expensive part for the consulting firm. And it's usually the last payment where the consulting firm makes their profits. In the beginning, it simply is expenses. You need to print materials, outsource to people, get equipment. So it's an expensive exercise. And therefore, the usual rule of thumb is that the consultant would require about 40% upfront, get 30% in the midterm, and 30% on completion. It's often the other way around. It could be 30% upfront, 30% in the midterm, and 40% on completion. This is all a negotiation process. There's no set rules for these things. My advice to any consulting firm, get as much as possible before the project, because that's where your expenses are. Your cash flow is in danger at the beginning of a project. At the end of the project, most of the work has been done and it's only about writing reports. Therefore, your profits lies in the last payment. Then we have to define the cost breakdown and the payment arrangements in terms of daily rate, hourly rate, retainer fee, etc. The cost breakdown has to be explained. How did we get to this cost? How do we break these costs down? Is the weighting system, is it based on a milestone? What are the reasons for this? So the cost breakdown is clearly explained in the contract. Then we need to explain the expenses. What are the rules and the limits here? How are we charged in terms of estimated budget? We need to be clear on this. What are the limits in terms of how much can we pay for accommodation, and what the client will not give the consulting firm an open checkbook for expenses. So what are the rules? Do we fly business class? Do we fly economy class? Be specific on what exactly the rules relating to the expenses are here. Let's have a look at intellectual property and copyright. This is a very important clause, since you want to protect your intellectual property and copyright, and the client wants to protect theirs. Let's look at intellectual property and copyright. This is a very important clause, since you want to protect your property, intellectual property and copyright, and the client would like to protect theirs. Therefore, there needs to be a specific clause that says whatever the consultant brings into this organization will be protected. It stays your copyright, your models, and your methodologies, whereas the client keeps copyright over their methodologies and things which you will have access to that has intellectual property. These could be creative work, copyrighted document, fundraising materials, logos, slogans. There's a various array of things that could be included in the intellectual property and copyright clause. Then there is the confidentiality clause. It's important that things of confidential nature stay that way, and it's also important that this confidential nature is clearly defined in the contract. There could be things that the client would keep. Obviously, the consultant, by nature of their work, would have access to very confidential information like strategies and certain policy documentation. Other documentation regarding employees, salary scales. There's many confidential information to which the consultant would have access. But there's also confidential nature which would give access to, which the client organization would access to, that belongs to the consulting firm. So the clause goes both ways. It's important that it's clearly defined that information both from the consulting firm and from the client firm be treated as confidential, and that none of this information would be made available to any third party. The contract is concluded with a signed agreement. This agreement is usually kept by both parties, and it's signed in duplicate so that each party could keep a signed copy. It's usually each signature, each person who represents the party signs in a block, and there's two witnesses that testifies that that's indeed that person who has signed there. And then it's made, there's two copies of this, one goes to the client and one to the consulting firm. It's important that the people who sign there has the authority to represent their institutions. If somebody signs for the consulting firm, such a person must be allowed to sign documents of this nature for the consulting firm, and if somebody signs on behalf of the client, then such a person must have the authority to do so. Make sure of this. It could lead to a lot of problems at a later stage when anything in the contract is being disputed. There are various types of contracts. Now, the first one I would like to discuss here, and I have done so earlier in this session, is the verbal agreement. The verbal agreement means that nothing has been signed. There's just a verbal agreement that there needs to be delivery on both sides. I know that this is not the right way, but I have successfully engaged in verbal agreement contracts where people would phone me and say, Derek, could you come tomorrow morning and facilitate something for us? And then I pitch up and they pay me. You know, there needs to be a very good relationship and a trust relationship for this to happen. I strongly recommend against this. Verbal agreements are valid, but they are very difficult to prove. So if you have a verbal agreement and this thing goes to court, it's going to be very difficult for you to prove who was responsible for what. So the choice is not to have a verbal agreement. The next contractual form is a letter of agreement. Now, very often the letter of agreement follows a verbal agreement. The letter of agreement is simply, usually client-initiated letter that states clearly that the consultant have been given this contract and that it's required of the consultant to perform the following. The consultant would then return with a letter of acceptance saying that he or she accepts this project. This could also be a client company writing to a consulting firm and the consulting firm accepting. So together these two letters make a contract. And where there's any dispute, it would be these letters of agreement that basically define what needs to be delivered on both sides. I strongly recommend that after a letter of agreement, the contract or the consulting assignment is concluded with a proper contract and not just a letter of agreement. But nevertheless, if there's only a letter, it would still be a valid agreement. Now we look at the written contract. Now much of this has been discussed earlier in the session. All those key elements to what should be in a contract should be in a written contract. This is a signed document and it clearly states that it's a contract. Therefore it abides to the rules of the contract, and it's usually drawn up by attorneys in law who knows what clauses to put in such a contract. Usually these things follow a sequence. First there's a verbal agreement, yes, you have the job. Then there's a letter of agreement that formally appoints you to this position, and then there's a written contract. Sometimes it's the other way around. You would have a verbal agreement, a written contract, and then a letter of instatement. The written contract, I'm not going to go through all the points again. It's the best form, especially in a consulting project that would have quite a long duration, so that if there are any disputes, we could fall back on this contract and look at what was promised in terms of delivery and in terms of payment. So this written contract is strongly recommended, and I do not believe that any consulting project should be engaged in without a proper written agreement. Lastly, we look at the psychological contract. Now this is very different to the previous ones, because the previous ones all gave legal obligations to perform. The psychological contract is more something between two people or parties where there's trust and integrity involved. The psychological contract is not codified in any document and cannot easily be described. It's a psychological contract under which the consultant and the client cooperate in an atmosphere of trust and respect, believing that the approach taken by the other party is the best one to bring the assignment to a successful completion. This contract cannot be replaced even in the finest legal document. If I have heard good things about a consultant and I've taken time to establish a relationship with this consultant, then I expect good things from this consultant. Now, although the psychological contract cannot be legally enforced, I tell you that it's the one that can cause the most damage. If people stop trusting you, stop believing in your integrity, and stop believing that the brand which you represent is a good one which will deliver results, well, then future work will be bleak and few. Now, so far in this session, we have discussed requirements for the contract. We've set what should be in this contract, what a contract is, and what would not be a contract. Let's end here with looking at the steps in generating a contract. Well, obviously the first step would be to create a title. We want to know what this is about. It's amazing to see many contracts that does not have this. But if it lies on a table, your table, my table, we would like to see what this is about, and we would like to file it appropriate. So it is a matter of good office management. Any contract should have a good title. Next is the name of the parties. Now, this seems quite straightforward. Who is concluding the contract with who? But often these are long names. You would, for instance, have the International Shell Petroleum Company enters in contract with Derek Hendrikz Consulting. So it's very difficult because these names have to appear in the contract quite a bit. Therefore, we shorten it. We say hereafter referred to as the client. Then wherever you want to talk about the company in future in the document, you just say client, and that would refer to this name. And the consulting firm, Derek Hendrikz Consulting, it could either be consulting firm or very often just DHC, in other words the initials for the full name. And if this is in the beginning of the contract, then we know that the rest of the contract would refer to these people in short. So the names of the parties can be shortened throughout the contract. Now we need to record the day on which the contract is concluded. This is usually in the beginning of the contract there's a date when the contract was drawn up, and at the end of the contract there's a date where it says contract signed on this day, which is usually then the number of the day, in other words 21st or 22nd of the month February 2014. It's very important to have, you cannot have a contract without a date, because whenever there's a dispute, this would be the first thing to determine when was this contract concluded. So date, very important. It must be clear in the contract. when this contract has been concluded, and when did these two parties agree on the outcomes that must be delivered here. Now we define the work that must be done. Much has been said about this in this session. I believe that one should not be too specific here, but give 3 or 4 broad objectives. You've defined the contract, you said that we have to facilitate a strategic session. Now you could broadly say we have to do a pre-session analysis, we have to get the session approved, we have to run the session, and we have to submit a report by the end of the session. My preference in terms of this is to give 3 or 4 objectives and then to attach a project plan to the contract. The project plan can be detailed. You see, it's much easier to change a project plan which is an annexure than it is to change the actual contract. So if you have broad objectives on what must be achieved, never more than 4, never less than 2. So 3 or 4 objectives are the perfect amount. Write them down in the contract. This is what must be achieved, and then you attach the project plan as an annexure to the contract, and the project plan can always be amended, and it's very specific in terms of what must be done. Then of course the compensation breakdown must be specified. How much is going to be paid to the consulting firm, and in which type of breakdown sessions will these be paid. I have discussed this early in the session, so we've talked a lot about this, but this needs to also be very clearly stated in the contract. You can see each of these sessions that I'm talking about here, each of these steps are literally paragraphs in the contract that must be there. Step 6 is to define the work relationship. Now this is mostly important for tax liabilities and also other liabilities. If the consultant is seen as an employee, then all of a sudden such consultant gets various benefits that the company owes him or her. So usually contracts have a clause that reads as follows: consultant's relationship with client will be that of an independent contractor, and nothing in this agreement is intended to or should be construed to create a partnership, agency, joint venture, or employment relationship. No part of consultant's compensation will be subject to withholding by the client or for the payment of any social security, federal, state, or any other employee payroll taxes. So it's very clear in this clause that there's no employment relationship, that this is a contract-based, project-based work that will begin and that will end, and that when it ends there is no continuation of this relationship. In other words, the consulting firm are just that, consultants. Now let's look at specific intellectual property and copyrights to parties, also something that I've discussed in length. This refers to any research, memorandums, graphics, software produced in the course of independent consultants' work, where the client is generally turned over to the client. If you're going to give something to the client, then it must be very specific and it must be defined as a work product. So it must be clear in the contract what stays your intellectual property and what you actually hand over. If they're paying you to develop something for them specifically, then you're also transferring intellectual property or copyright of something. Maybe I'm writing a document for these people, then they would keep the copyright. This must be clear in the contract so that there's no further ambiguity about this. It has happened in the past that client companies have sued consulting firms because they have used the same models which they've developed for the client company in other companies. And then the dispute would be about, is the intellectual property transferred or is it not? The clause would typically read as follows: consultant agrees that all work product development by him or her alone, in or in conjunction with others in connection with the performance of services pursuant to this agreement, is and shall be the sole property of the client, and consultant shall retain no ownership, interest, or rights therein. Work product includes, but is not limited to, the reports, graphics, memorandums, slogans, taglines, etc. So we are stating exactly what is transferred and what is not transferred. Very important clause. A lot of disputes in consulting contracts are about this specific clause. Then each contract should define a confidentiality agreement. Usually the consultant, as I've discussed earlier in the session, would have privy to confident and secret information. You need this to do your work. You might have access to formulas or strategies which the client company does not want other people to see. In the contract, it would usually prohibit you to disclose any confidential information to other parties. And there would usually be an exception where it says that you may disclose such information if you're ordered so by court. But I haven't seen any consulting contract drawn up or advised by a client company where they are not quite serious about the confidentiality clause. In fact, I would say that the intellectual property clause is often more important to the consulting firm, and the confidentiality clause is more important to the client firm, the contracting firm, in other words. Standard clauses are clauses which are often included in the contract. One of these, the first one, would be the choice of law, especially in today's times where consulting firm and client company is not necessarily in the same country, or the client company could be in a variety of countries where the consultant has to perform work. So it must be clear which country's law is made here. This is usually the client company's country where the contract has been drawn up. In other words, if I'm from South Africa and the client company is from Malaysia, then it would usually be the Malaysian law that governs the rules of this contract. A second standard clause is severability. Severability are common in all types of contracts and simply say that in any clause of the contract is found to be unenforceable, other clauses shall remain unchanged. In other words, the fact that there is one clause in the contract that cannot be enforced does not mean that the other clauses are also not valid. Then a very important standard clause is relief for breach of contract. This is basically a clause where the client may force performance by the consultant if there's any breach. It would typically read as follows. Consultant agrees that her obligations under this agreement are of unique character that gives them particular value. Consultant's breach of any such obligations will result in irreparable and continuing damage to the client for which there will be no adequate remedy at law, and that in the event of such a breach, the client will be entitled to injunctive relief or a degree of specific performance and such other and further relief as may be proper, including monetary damages if appropriate. So the client protects themselves against consultant non-performance, and of course they protect their own continuity of business. The contract is ended with a signature block. This is a block with space, or usually a table, where both parties can sign and witnesses that they have signed are there. It is common practice for each party to have their own witnesses. I have discussed this quite thoroughly earlier in this session. The only thing left here is to format the contract. Make sure that it's numbered clearly. Do not have unnumbered clauses or even paragraphs. Make sure that it's numbered, because when you refer to a contract, you would refer to page 7, paragraph 4.3. You could have your paragraphs under 1, 2, 3, 4, and then under each paragraph the clause could take on that number of the paragraph itself. In other words, paragraph 4 would have clauses 4.1, 4.2, 4.3. In that way we can refer to what we dispute, and we can refer to specific obligations in the contract without being vague. Secondly, leave spacings in equal ways. In other words, if you space 2 spaces between a paragraph, then it should go through right through. Make your paragraphs a different font, or bold or underline it. So there should be a general, easy, understandable format. Remember, nobody takes a contract, lies on their bed and reads it through on a Sunday afternoon. That's not what we do with contracts. Nobody reads them. This is about getting to information quite quickly. So it's about referencing, it's about referring to specific clauses on specific pages. I've seen contracts without page numbers. That's just ridiculous. So make sure it's got a nice feel, and that it's got a nice format to it. Lastly, remember that your contract should be flexible. The purpose of a contract is to protect the interest of all parties involved. And things change, and you need a bit of creativity in contract. So flexibility is very important. Don't have a contract that's too tight. This would definitely set you up for failure.